It seems to me that much of the strategy taken so far from a lawyer's standpoint makes pretty good sense. The strategy has involved looking at different dispute settlement organs, different courts and tribunals that are available. You're not going to, it's very unlikely that you're going to achieve a sort of thunderbolt victory at a court and then all of a sudden Russia is going to withdraw from Crimea. Not likely to happen. But it's absolutely critical that you maintain a strong position that makes it totally clear that you do not accept the status quo. You're not going to accept the status quo, and it helps also to keep your allies and your friends on notice that you're not giving in on this. And especially, the countries that are probably Ukraine's best friends, the United States, the Western European countries, are pretty legalistic. It's much the stronger your legal positions, the easier it is to make your arguments to parliaments and to Congress and so on. I think the institution of proceedings at the International Court of Justice makes good sense. I haven't seen the papers, the submitted papers, which I don't think are yet public, but it sounds like the government has done a smart job of looking at Georgia's case against Russia from 2008. Georgia, in retrospect, was a little bit precipitous. They should have set the stage a little more carefully. There are in many of the treaties that create jurisdiction in international courts and tribunals, you have requirements to negotiate before you institute proceedings. I think there's a certain delicacy here because I don't think Ukraine should negotiate the status of Crimea, and Ukraine has been smart not to negotiate the status of Crimea, but it has set the stage, I think, pretty skillfully for the case at the International Court of Justice by sending out diplomatic communications to Russia saying, look, this is not acceptable. Let us sit down and sort this out, meaning let's find a modality, a procedure for you to get out of Crimea. That makes good sense because then you can say, look, we've attempted to deal with this outside of court. Hasn't worked. No progress. It's been a couple of years now. At this point, it is time to go to court. So I think that looks. I have a certain sort of a cautious optimism about that. Repeating, but to repeat, obviously these cases when you're dealing with the sort of, it really is aggression, armed aggression. It's not likely you're going to get it's not a magic bullet, but I think it's the right thing to do. I think it's right also to have looked at the investment case, the investment treaty. There's a Ukraine-Russia investment treaty. Investment law was not designed to deal with armed aggression. That's not why you have investment treaties. Investment treaties are so you can get down to business and have economic growth and development. But there is some possibility that Ukraine could get some traction through those treaties, and it's been reported that there are a handful of cases now under the Ukraine-Russia bilateral treaty. I think that makes sense. I think you want to keep as much pressure on Russia through legal channels as you can. I mean, compared to fighting a war, it's pretty cheap. It's not a huge expenditure. It's not negligible, but compared to the cost of the conflict in Donbass, it's not that much of a burden. But it helps communicate to the world that you're not giving in on any of the positions. And if you can get something, if you can get an organ of the UN. Like the International Court of Justice, to add its voice to your case, to your side, that's helpful. You already have the General Assembly, which has passed two, I think, quite useful resolutions, making clear Crimea is part of Ukraine. It's now clear that all UN organs, including the human rights organs, if they deal with Crimea, have to go through Kiev. They are not to go through Moscow.